Hello everyone and welcome to BearNews as we take a look at some serious allegations surrounding Activision Blizzard. Now for those who don't know, Activision Blizzard is currently dealing with a lawsuit from the state of California. And it should be stated now that the Department of Fair Employment and Housing has been investigating their company for 2 years, meaning there has been an ongoing investigation even prior to the current complaints that have come to light. And so we'll be taking a look at this lawsuit, as well as the responses by the company to them, the ensuing walkout by its employees, as well as some additional events that have occurred after the fact. Now I will state now that I will be reading some sections word for word, though others I will attempt to summarize. If you wish to see a copy of the lawsuit for yourself and read through it on your own time, then I have included a link in the description for any who wish to do so. The allegations surrounding Blizzard Activision range all the way from the general workplace environment to more specific claims of harassment within the workplace, as well as work-related activities. Following prior complaints of burnout within the gaming industry, it is clear that things are not as well as they may seem, and just as any other industry, it should be held under scrutiny and its members held to account for their actions. Taking a look then directly at the lawsuit, let's have a see what the facts of the situation are. To begin with, we can see that the plaintiff is the Department of Fair Employment and Housing, or DFEH as it will be referred to throughout the document. This is an agency that is run by the state of California and has filed their complaints based on the Government Code Section 12900, as well as the California Equal Pay Act of Labor Code Section 1197.5. Filing this against the defendants Activision Blizzard Incorporated, Blizzard Entertainment Incorporated, Activision Publishing Incorporated, as well as 10 individuals, collectively referred to as defendants or individually as DOEs. This is to say that their name is not made public or known at this point. Now it is important to note these prior to reading through, as this will show whereabouts the complaints are directed in each case. Starting out from the introduction, DFEH outlines that Activision Blizzard's headquarters are based in California and thus it is subject to Californian law. And taking a look at Section 1, they also point out that sexism has plagued the male-dominated gaming industry for decades, while also suggesting the fact that women and girls now make up almost half of all gamers within America, with Activision Blizzard seeing a double-digit percentage growth atop a 10-figure annual revenue. Though despite these profits and the seemingly changing market of the gaming community, diversity marketing campaigns have unfortunately changed little, as well as stating that the defendant's compliance with California's broad workplace protections is long overdue, which has led the DFEH to enforce such compliance by bringing forth this government enforcement action, seeking to remedy, prevent, and deter defendants' violations of the state's civil rights and equal pay laws. The document then proceeds to further outline Activision Blizzard's company as a whole, stating them as a member of the Fortune 500 and S&P 500. It then proceeds to outline the various games and enterprises of the company, with keynotes of the Call of Duty franchise, World of Warcraft, Diablo, and Overwatch, as well as stating some of the subsidiaries that it conducts its business through: Blizzard Entertainment Incorporated, King Digital Entertainment, and Activision Publishing Incorporated, among others. Now we note very quickly in Section 3, where the document states that unlike its customer base of increasingly diverse players, the defendant's workplace is only about 20% women. Its top leadership is exclusively male and white. The CEO and president roles are now and have always been held by white men. Very few women ever reach top roles within the company, and the women who do reach higher roles earn less salary, incentive pay, and total compensation than their male peers, stating as evidence in defendants' own records, with a table then providing a summary of compensations to various members within the company, with dates ranging from 2018 through to 2020. Now, alongside the low percentage of women workers and a lack of representation within the higher levels of the company, we also see suggestions that these female employees not only are receiving far less within their wages, but in fact were receiving lower starting pay and earning less than male employees for substantially similar work. Even at the very beginnings of their careers, were being assigned to lower paid positions and were struggling then to gain promotions within the workplace, and even suggesting that they would be terminated more quickly than their male counterparts, with the very terms and conditions of their employment being suggested as the reason why women had been forced to leave the company. The lawsuit states further that this discrimination extends to the overall workplace environment, referring to it as a pervasive frat boy workplace culture that continued to thrive, with allegations of such unprofessional workplace behavior as cube crawls, where members of staff would engage in drinking copious amounts of alcohol as they would crawl between the various cubicles of the office, and often engaging in inappropriate behavior toward female employees, before then entering the workplace the next day proudly hungover, delegating their duties during this time to the female members of staff, taking this chance to engage in banter about sexual encounters, talk openly about their female colleagues, and joke about rape. The allegations regarding this frat boy culture extends further to specific accounts of sexual harassment, including, in particular, a female employee committing suicide during a business trip with a male supervisor who police had found plugs and lubricant with them upon the trip. Now, I will note, stated within the lawsuit, that the defendants continuously condone the quid pro quo and hostile work environment. The message is not lost on their employees. And as we continue on, the document states that numerous complaints about unlawful harassment, discrimination, and retaliation were made to the defendants' human resources personnel and executives, including to the very president of Blizzard Entertainment. However, it states defendants failed to take effective remedial measures in response to these complaints, where employees were then further discouraged from complaining as human resource personnel were known to be close to the alleged harassers. An internal investigation into the Human Resource Unit noted that there was a big lack of trust and that HR was not held in high regard within the company, with in fact employees' complaints being treated in a perfunctory and dismissive manner and not being kept confidential. As a result, leaving the complainers, in this case the female employees, subject to retaliation, including but not limited to being deprived of work on projects, and unwillingly transferred to different units and selected for layoffs. Now, the environment described within this document is not only unacceptable, but quite clearly unlawful. It is to this outline that the lawsuit has been filed. The document states that the DFEH's enforcement action seeks to remedy, prevent, and deter unlawful harassment, retaliation, and discrimination. Specifically, and once more I quote, "The violations pled herein include claims of sex discrimination in terms and condition of employment, including compensation, assignment, promotion, constructive discharge, termination, unlawful sexual harassment, retaliation, failure to prevent discrimination, harassment and retaliation, and unequal pay." The document then continues to describe the parties involved, with Article 9 stating that the plaintiff is the Department of Fair Employment and Housing. The document then goes on to define the parties involved, as I have stated in the initial introduction. Though if I come to Article 13, we currently have defendants Does 1 through 10, and this is because the DFEH is ignorant of the true names or capacities of the defendants sued herein under the fictitious names Does 1 through 10 inclusively, meaning that the exact identities of the individuals involved is unknown. However, the lawsuit is still brought to bear against them, as the document continues that DFEH will amend this complaint to allege their true names and capacities when the same are ascertained, meaning that the names of these individuals will be brought to bear once their true names can be discerned. And it further continues in Article 14 that DFEH is informed, believes, and alleges that at all relevant times each defendant is and was the director, agent, employee, and/or representative of every other defendant and acted within the course and scope of their agency, service, employment, and/or representation. The next section, entitled Procedural History, Jurisdiction, and Venue, presents the fact that as Activision Blizzard is based within California, it is thus suspect to the Californian law. The next section, entitled Procedural History, Jurisdiction, and Venue, stating that on October the 29th of 2018, an amended director's complaint was filed and served to add Activision Blizzard Incorporated. On December the 7th of 2018, a second amended director's complaint was filed and served to add Activision Publishing Incorporated. The director's complaint alleged that the defendants engaged in discrimination against their employees on the basis of sex, gender, including failing to hire, select, or employ persons because of their sex, as well as discrimination in compensations or in the terms, conditions, privileges of employment due to their sex. It then continues that the director's complaints further allege that the defendants failed to take all reasonable steps to prevent unlawful discrimination, harassment, or retaliation. And moving on to Article 18, after more than 2 years of investigation, DFEH issued a cause finding on June 24, 2021. In the course of DFEH's investigation, DFEH found evidence that defendants discriminated against female employees in terms and conditions of employment, including compensation, assignment, promotion, termination, constructive discharge, and retaliation, and finishes by stating the investigation found that defendants failed to take all reasonable steps to prevent unlawful discrimination, and concludes that DFEH's investigation further found that defendants had committed violations of Labor Code Section 1197.5 in paying female employees less than their male counterparts for substantially similar work. It does declare that these claims are alleged and/or reasonably related to and like the claims originally alleged in the director's complaints. This shows that the investigation has been ongoing for some time and only coming to light with the lawsuit as it has been filed. It furthers itself that the DFEH attempted to resolve this matter without litigation prior to filing the civil action. The DFEH required all parties to participate in mandatory dispute resolution in the department's internal dispute resolution division free of charge to the parties in an effort to resolve the dispute without litigation. Specifically, DFEH invited defendants to participate in a mediation session with the department's internal dispute resolution division on July the 1st, 2nd, and 15th of 2021, but the parties were unable to resolve the administrative complaints. And as such, stated in Article 20, in the case of failure to eliminate an unlawful practice through conference, conciliation, mediation, or persuasion, or in advance thereof, if circumstances warrant, the DFEH may bring a civil action in the name of the department in state and federal courts. And so it is from this 2-year investigation and attempts to resolve without litigation that this lawsuit has come to pass. The final 3 sections simply stating that all administrative procedures have been fulfilled, including a signed agreement between parties following the deadline of July 21st, 2021, and that the amount of damages sought by this complaint exceeds the minimum jurisdiction limits of this court. The next section, Government Enforcement Action Allegations, covers the legality of the lawsuit once more, as well as the history of notice, filing, and complaints. It simply continues to reinstate the legality of the lawsuit in regards to all laws accounted for and the parties involved. Moving on to the next section, we have factual allegations. In reference to sex discrimination, pay, assignment, promotion, termination, and constructive discharge. This section begins stating, the defendants have engaged in and continue to perpetuate discriminatory practices regarding pay, assignment, promotion, and other terms and conditions of employment which negatively affect and impact female employees. These discriminatory acts, beginning at the point of hiring, where women had been offered lower compensation and less lucrative job assignments and opportunities than their male counterparts, setting the foundations for such acts to continue. They take note that not only was payment at initial point of employment, but also throughout employment unfair towards female employees, where they would continue to be paid significantly less. Atop this, women were also afforded less stock and incentive pay opportunities, where female employees were overwhelmingly assigned into lower grades or levels without stock and incentive pay. Extending this again in regards to compensation. I should note that each time each article ends with a statement, this pattern or practice and violations were continuing. Section 35 then states that with women having been steered into lower levels of the defendant's hierarchy, that they would often have to work harder and longer to earn equal promotion and other opportunities as their male counterparts, with an example being stated that a female employee working for Blizzard Entertainment was assigned to a lower level, denied equal pay, and subsequently sought a promotion because she had been carrying out duties exceeding her job description. She was repeatedly told it was not her turn and others deserved a promotion ahead of her. Ultimately, the employee was promoted after 3 years, while her male counterparts were promoted within a year of their hire, despite having started several months after her. Additionally, the male counterparts were assigned leadership roles and responsibility, though these were not further afforded to female employees, all of which will have furthered the male employee's ability to get promoted. These examples are then continued, with various different forms of discrimination accounted within them, even going so far as to state that male supervisors would refuse to communicate with female employees, going to their male counterparts instead for information. Importantly, looking at Article 39, it accounts an example of a female employee taking on the responsibility of their own manager, but when asking their male supervisors about being paid fairly for the work they were actually doing and promoted into that position, the manager commented that they would not risk promoting her as she might get pregnant and like being a mum too much. With the document furthering this by stating in general female employees were further treated negatively due to their pregnancies. Supervisors ignored medical restrictions given to female employees and gave them negative evaluations while they were out on maternity leave, with other female employees reporting that they were criticized for leaving to pick up their children from daycare while their male counterparts were playing video games, and female employees were kicked out of lactation rooms so employees could use the room for meetings. We also note in Article 40 that women of color were particularly vulnerable targets of the defendant's discriminatory practices, with an African American employee noting that it took 2 years to be made into a permanent employee, while male men hired after her were made permanent employees prior, suggesting that the discriminatory practice was not restricted to the lines of gender, but would also take into account the race of the individual in question. All of which it finishes by stating that these experiences led female employees to leave their employment with the defendants. Article 41 then summarizing that as a result of these discriminatory pay, assignment, promotion and other practices, the defendant's gender pay gap is significant. The defendants paid female employees significantly less in base pay and total compensation than their male counterparts. This pattern of practice and violation, once more, were continuing. And Article 42 states that when women complained to human resource personnel about the lack of equal employment opportunities, their complaints fell on deaf ears or were met with empty promises to investigate the situation. All of this resulting in female employees being forced to leave their employment with the defendants. The section finalizes by summarizing the articles, as well as stating that the defendants failed to take effective steps to remedy or adequately correct its compensation disparities despite its awareness that some disparities existed, with the defendants' discriminatory practices continuing to the date of this complaint. And in moving on to the section entitled Sexual Harassment, female employees almost universally confirmed that working for the defendants was akin to working in a frat house, stating that this involved male employees drinking and subjecting female employees to sexual harassment with no repercussion, with the section continuing to state that not only verbal harassment had occurred, but also groping and unwanted physical touching. The article provides examples that female employees working for the World of Warcraft team noted that male employees and supervisors would hit on them, making derogatory comments about rape and otherwise engage in demeaning behavior. This behavior was known to supervisors and indeed encouraged by them, including a male supervisor openly encouraging a male subordinate to buy a night walker to cure their bad mood, with Article 47 stating that a blatant example of the defendant's refusal to deal with a harasser owing to their seniority and position, the former senior creative director of World of Warcraft at Blizzard Entertainment was permitted to engage in blatant sexual harassment with little to no repercussions, stating that they would hit on female employees, telling them they wished to marry them, attempting to kiss them, and putting their arms around them. This allegedly in plain view of other male employees, including supervisors who had to intervene and pull them off female employees. Finishing with Article 48, with a tragic example of the harassment that defendants allowed to fester in their offices. A female employee committed suicide while on a company trip due to a sexual relationship that she had been having with their male supervisor. The male supervisor was found by police to have brought a plug and lubricant on their business trip, with another employee confirming that the deceased female employee may have been suffering from other sexual harassment at work prior to her death, specifically in regards to a holiday party before her death where male co-workers allegedly passing around a compromising picture of the deceased. Our next section is entitled Retaliation and Defendants' Failure to Prevent Discrimination, Harassment and Retaliation, stating clearly in Article 49 that the problems of harassment and discrimination extended to and at minimum were known to those at the top, with the defendant's former chief technology officer having observed employees groping inebriated female employees at company events and was known for making hiring decisions based on female applicants' looks, with an employee even complaining to Blizzard Entertainment president in early 2019 that employees were leaving due to sexual harassment and sexism. Specifically, this employee noted that women on the Battle.net team were subjected to disparaging comments. The environment was akin to working in a frat house, that the women who were not huge gamers or core gamers and not into the party scene were excluded and treated as outsiders. Article 50 then further emphasizing this by stating that female employees had raised further complaints to various human resources personnel about the discrimination they faced, including but not limited to complaints about unfair pay and assignments, male co-workers belittling them or minimizing their contributions, and male counterparts being promoted quickly despite their lack of seniority. Additionally, they also raised complaints about the harassment they had suffered, including that male co-workers groped them, that male supervisors asked them on dates, and of other unwanted harassment. The defendants had failed to take reasonable action in response to these complaints, and such lack of effective remedial measures was not surprisingly given defendants' own internal investigation into their human resources unit noted that there was a big lack of trust and that HR not held in high regard, with multiple employees also noting that their complaints were not kept confidential, with Article 51 speaking towards the retaliation felt by female employees to these complaints, including involuntary transfers, selection for layoffs, and denial of projects and other opportunities. Article 52 stating the defendants' flawed policies and practices effectively allowed and continued to allow discrimination to occur in defendants' workplace. Employees have suffered and will continue to suffer harm from defendants' ongoing unlawful policies and practices unless they are enjoined by this court, with the additional 10 causes of action stating the legal reasons from which this complaint has been brought to pass. The final section is entitled The Prayer for Relief, wherefore DFEH prays that this court issue judgment in favor of DFEH and against defendants' ordering. 1. Compensatory and punitive damages. 2. Unpaid wages, liquidated damages, and other remedies and penalties available under the Equal Pay Act. 3. Injunctive relief. 4. Declaratory relief. 5. Equitable relief, including but not limited to reinstatement and/or front pay, pay adjustments, back pay, lost wages and benefits, including base pay, incentive pay, pension benefits, and awards in an amount to be proven at trial. 6. Prejudgment interest as required by law. 7. Attorneys' fees and costs to the Department of Fair Employment and Housing. And 8. Other relief the court deems to be just and proper. The document then signed for the attorneys for the department. Activision Blizzard proceeded to then provide a company statement, presenting it to various publications and calling the lawsuit irresponsible behavior from unaccountable state bureaucrats that are driving many of the state's best businesses out of California. The copy you can see on the screen comes from The Verge, and I'll be including a link in the description for any who wish to see the full article as well as the statement that was provided to them. Within the statement, Activision Blizzard declares that the company values diversity and strives to foster a workplace that offers inclusivity for everyone, and that there's no place within their company or any industry for sexual misconduct or harassment of any kind. They're taking the allegations seriously and investigate all claims in cases related to misconduct, and that action was taken to address the issue. Paraphrasing, if I may, they then proceed to state the DFEH has included distorted and, in many cases, false descriptions of Blizzard's past, stating that they were in fact cooperative with the DFEH throughout their investigation, including the provision of extensive data and ample documentation, in fact declaring that Activision Blizzard was refused an explanation as to what issues the DFEH had perceived, announcing that DFEH was required by law to adequately investigate and to have good faith discussions with, in this case, Blizzard, to better understand and to resolve any claims or concerns before going to litigation, announcing here that the DFEH had failed to do so, even going so far as to state that Blizzard is sickened by the reprehensible conduct of the DFEH to drag into the complaint the tragic suicide of an employee who, and I quote, has no bearing whatsoever on this case and with no regard for their grieving family. Blizzard finds the behavior to be disgraceful and unprofessional, and unfortunately an example of how the DFEH had conducted themselves throughout the course of their investigations. The company statement then proceeds to outline the various measures and efforts they have in creating a fair and rewarding compensation package for their various employees, ensuring that all employees are paid fairly for equal or substantially similar work, ensuring through a variety of proactive steps that ensure that pay is driven by non-discriminatory factors, before finishing, and I quote from Blizzard, We are confident in our ability to demonstrate our practices as an equal opportunity employer that fosters a supportive, diverse, and inclusive workplace for our people, and we are committed to continuing this effort in the years to come. It is a shame that the DFEH did not want to engage with us on what they thought they were seeing in their investigation. With the employees at Activision Blizzard writing an open letter to their executives with over 2,000 signatures condemning the company's statements as they stand. Given the sheer quantity of allegations and proven misconduct within the gaming industry, it comes to show that there is a current lack of scrutinization within the gaming industry at large, and a general lack of accountability held by many of its members. And so regardless of the outcome of these specific cases, it is still going to be interesting to see how the gaming industry is reshaped pressing forward so as to regain the trust not only from the gaming community but also the gaming developers themselves. Now, in the wake of these events, the Activision Blizzard employees took it upon themselves to engage in a walkout. The Activision Blizzard walkout, or #ActiBlizzWalkout, saw many of the company's employees taking to the streets, standing shoulder to shoulder, stating various signage ranging from the fact that women in the video game industry deserve a safe place to work, through to the fact that we should fight bad guys in-game and fight bad guys in real life. The general statement from the employees of Activision Blizzard has been one of unity, with many of them coming together in this walkout, and even those physically unable to attend taking it upon themselves to have a digital walkout. Now, I should note that journalists were instructed not to interview the employees, as it may have led to outing the sources for the current lawsuit in action. This being said, the employees were still able to provide some statements, with company employees saying that right now the companies and their executives are not listening to them, and that they have made this clear, showing an apparent disconnect between the top brass and the everyday workforce. Now, the walkout representative, when asked about plans to unionize, they simply stated that they have no comment. However, they did leave by saying, "We're taking something that has existed and permeated through the gaming industry for decades and beginning to build a movement. And as such, it's important to remember where we came from with our demands, what the end goal is, and not lose sight of that." Now, I will say, since the initial response that caused much of this controversy within the employees, there have been additional statements by the higher-ups of Activision Blizzard. For example, the executive sponsor of the ABK Employee Women's Network and their chief compliance officer taking the time to readjust their statement and try to make it clearer what exactly it was they were saying, ensuring to iterate that they are proud to be a part of the company that takes a hard-line approach to inappropriate or hostile work environments and sexual harassment issues, stating that their Speak Up campaign reinforces their zero tolerance for retaliation against those who do speak up, and that the company has made significant investments to foster inclusive behaviors and to reflect greater diversity within their leadership teams, including, and they proceed to provide a list of the different actions that have taken place within Activision Blizzard, as well as other members of the top tier of the company, stating that the allegations from the Department of Fair Employment and Housing in California are deeply disturbing, and in their own words say, "Let me be clear, there is zero tolerance for this type of behavior in our workplace or frankly in our society. We as a company take every allegation seriously and investigate all claims. When wrongdoing is found, those responsible are held accountable, and we will continue to do so. Each of you deserves to be treated with dignity, equality, and respect at all times. Behaviors described are not reflective of our Activision company values, especially champion DE&I, and it's the people. Our values are not just words on a page, they are at the core of who we are day to day and who we aspire to be for years to come." Before finishing with, "Please join me in ensuring that we continue to consistently cultivate an inclusive environment where everyone feels respected, safe, and valued. Anything less than that is unacceptable to me." Now, all of this has not been restricted to Activision Blizzard as of the year 2021. In fact, there have been prior cases with multiple companies being investigated for sexual harassment and discrimination cases. For example, the California DFEH actually was involved with a major sexual harassment and discrimination suit against Riot Games. One that, though initially landing at a settlement of $10 million, before the DFEH suggested it should be more than $400 million. As well as Ubisoft being embroiled in a sexual harassment scandal just last year, one where once more, the roots may go back a decade, in accordance with a survey held in October. stating that within this anonymous survey, where nearly 14,000 employees took part, 1 in 4 respondents said that they had either witnessed or experienced workplace misconduct themselves in the past 2 years, and 1 in 5 said that they didn't feel fully represented or safe in the work environment. The results also noted that women and non-binary employees witnessed or were more likely to experience or witness harassment than men. Now, suffice to say that the gaming industry has been under quite large scrutiny, with multiple questions being brought into its conduct, with only recently video game creator burnout being the hot topic surrounding the gaming industry. Now, I will state clearly right here, there are of course multiple gaming companies that have not fostered this sort of workplace environment. And of course, with lawsuits ongoing, it cannot be confirmed as to the validity of each statement as it's brought forth. That being said, the sheer quantity of statements and number of companies that have been brought under this scrutiny is truly shocking. Given how there has been an increased scrutiny within the gaming industry of late, with so many of these high-priority cases coming to light, it would suggest the public needs to be holding these companies more accountable for their actions and ensuring that all members of staff, regardless of their background or identity, should be held in equal regard and afforded the same opportunities as any other. By denying the potential of the individual, you are not only harming your business, you are also directly preventing gamers from enjoying the games that they might create. Now, in the wake of the story surrounding the lawsuit and walkout, there have been plenty of new occurrences within Activision Blizzard as well as the gaming industry as a whole, with in fact additional lawsuits being brought towards Activision Blizzard in regards to their ever-falling stock prices. The reason this has come to pass is that stockholders are suggesting that the leadership of Activision Blizzard allowed through their negligence the price of the stock to decrease. This fall in stock not only pertaining to the lawsuit itself from the Californian Department of Fair Employment and Housing, but also in regards to the tone-deaf reply that Activision Blizzard had provided, suggesting that the handling of this lawsuit has been somewhat of a mishap from the very beginning and having negative effects upon the company in such a way that the shareholders feel they are due compensation. And I should note I include this not only because it is news surrounding the situation, but also for the simple fact that nothing speaks louder to a company than finances, and any change in the stock pricing as well as the actual stockholders themselves is going to have a massive impact in how the company performs, essentially being a great sign for those who are following this case, as for no other reason than it is holding the Activision Blizzard leadership to account for their statements. Now, we can also note some big changes in the leadership itself from Activision Blizzard, with a key example being in regards to its HR department. Now, alongside the removal of its head of HR, Activision Blizzard also released a statement. "We will not tolerate anyone found to have impeded the integrity of our processes for evaluating claims and imposing appropriate consequences," adding that if employees have any concerns about how human resources handled claims, we had other reporting options, including anonymous ones. The statement does give some hope that things are changing, however, actions speak significantly louder than words when it comes to these sort of situations. Now, I should also note that many employees have seen a high turnover in HR and a general lack of a paper trail in many circumstances, which have contributed to the dysfunction and lack of trust that employees had with this department. And although changing the head of HR, which the California lawsuit had already alleged had failed to protect employees and properly address issues when they were reported, this continued turnover does draw into question just how things will progress in the future. And as we progress on in events, even now the Blizzard president has stepped down in response to workers' demands for systemic change. With the president stepping down and the head of HR also leaving, just how much more change can we expect in the future from Activision Blizzard? And just how will the newly grouped ABK Workers Alliance succeed in having their demands met? Which, if we take a look at an article by PC Game SN, we get a nice breakdown of those demands. Number 1, the end of forced arbitration in employment agreements. Number 2, the adoption of inclusive recruitment and hiring practices. Number 3, increases in pay transparency through compensation metrics. And number 4, an audit of ABK policies and practices to be performed by a neutral third party. Importantly, They demanded that this third party be selected by an employee-led diversity, equity, and inclusion task force. Now, this has been a rather hard video to put together, going across multiple sources, and I will be endeavoring to ensure that as much of information as possible can be found within the description for any and all who wish to find out more about this. And I genuinely wish you do so. Holding companies to account for their actions is something that all members of the public must do, though particularly those who wish to enjoy their products. And to any and all who've been affected by such serious matters as this, do know that you do not stand alone. And until next time, as always, peace out.